Tribunal is going to form and start working expectedly by October 2025, unless until any other thing does not come forward, because lately a writ petition has been filed in Odisha High Court wherein the constitution of the tribunal has again been challenged, and the matter has been taken by the Odisha High Court and stay has been granted. So 8 years after implementation of GST, we are yet to see the GST tribunal, and this would be the one of the most significant implementation post GST, because what we are seeing on the ground level, the hierarchy which we are seeing on the ground level, is nothing but due to non-constitution of the tribunal, because the litigations or the issues are not being analyzed in the manner they should have been in the legal, in the light of the legal principles. So we hope and expect that GST tribunal will be constituted soon. Starting with rights and duties. My entire session, initially I was given 2 hours, but due to the inaugural session and that was expected, I have been given a shortened time of 1.5 hours and try to complete and do justice with the topic. So whatever time has been given, the 1.5 hours, let's conclude one thing, that whatever we are discussing, we would not be thinking that even if I write this in my submission, the officer is not going to accept, so why do I write a detailed written submission? We are not writing a detailed written submission so that the officer may accept it. We have to be firm that the officer would not going to accept it. But there is a merit that why should we write a detailed written submission, and as we go on discussion, with the discussion, we will be discussing on the various aspects which the courts have observed, that if the issue was not raised at the initial point of the written submission, they are not accepted even in the writ proceeding, that why that issue was not raised in the initial written submissions. So starting with the session, whenever I start a session, I start the session with the basic fundamentals. See, in 1.5 hours, I am not going to detail and discuss each and every aspect of the litigation. But if we are able to discuss on the fundamental aspects of the litigation, then there would be some benefit to the members who have come across to attend this session. So this is the first slide, and my first question to you, that supposedly you have received a notice for the first 3 lines, wherein notice was issued under section 73 for 2017-18 for ITC excess claimed in GSTR 3B vis-a-vis ITC reflecting in GSTR 2A. Does anybody see any deficiency in these lines? Or this is a complete notice which we receive and we normally reply to this notice? Yes, sir? Time bar. Leave aside time barring. 2A was not implemented in 17-18. Yes, sir. Any other issue, sir? Any other issue which we see in these 3 lines? Section 74, 17-18, that's why 74, treated as 2021 or 21-22. Let's, because the time is short, so I would be cutting down on this aspect. Covering penalty and excess claim. Sir, section 73 is a section for determination of liability. Does it speaks what offense has been committed? It only speaks that ITC has been wrongly availed or wrongly utilized. This is the thing. So in which provision it has been wrongly availed or wrongly utilized? Does section 73 says? So whenever an officer is issuing me a notice, the first prerogative is in which section the ITC was wrongly availed or wrongly utilized. Does these three lines specify which section was invoked by the officer for coming to the conclusion that ITC was wrongly availed or utilized? These three lines are not giving any indication. And this is the first point, that whenever we receive a notice, first try to see that what is the provision which I have not fulfilled. This is the onus on the officer to tell me that under which provision he has thought that ITC was wrongly availed or wrongly utilized. Else, what I have to do? I have to make my submission right from section 1 to section 174. If I am ready to give my submission on these three lines, then I have to search from section 1 to section 174 of CGST Act that what is the relevant provision in which I have committed the default. Why I am saying so? Because the officer himself does not know what is the provision which has to be invoked for 1718. We are ourselves saying that 2A was not operational. So sir, when 2A was not operational, let the officer say what is the section which has to be invoked. And if he is, because once a section has been invoked in a show cause notice, the order cannot go beyond that. So if it is invoked incorrect section, the order cannot go beyond that, and my written submission has to be limited to that provision only. We'll discuss it, sir. Second, the notice provided that why the penalty shall not be levied under the provision of section 122. Do we see any issue with these three lines? We commonly receive this notice. We commonly receive these notice that why not a penalty. First they state the offense, that this is the offense committed. Then they say that why the penalty shall not be levied under section 122. Do we see any issue with these three lines?
Ambiguous.
Ambiguous? Yes, sir. People sitting at the back. This is a session for everyone who is sitting in these four walls. Any issue with these three lines? The background is coming from the above three lines only.
Violation section not specified.
Yes, sir?
Section violated not specified.
Yes, sir. Very true, sir. Section 122, subsection 1, 21 offences. Section 122, 1 capital A, 5 offences. Section 122, subsection 2, 10 offences. Section 122, subsection 3, at least 5 offences. So there are 40 to 45 offences in section 122. And when I receive this notice, that means all the 45 offences have been committed by me. If he is saying that why not a penalty shall be levied under section 122, all the 45 offences have been committed by me. Now what we do when we receive this notice, supposedly the notice is for wrong availment of ITC. We say that I have not committed any default under section 122, subsection 1, clause 7. Because I have duly received the goods and I was entitled to claim the ITC. Officer said that's what I wanted. I was also not sure which section to invoke. You have taught me that 122.17 was to invoke, and that's why you have committed a default under section 122 subsection 1 clause 7. So this is the help we are giving it to the department. Sir, my claim of transitional credit, be that case maybe however strong it was on fundamental basis, I had all the invoices, I had received the goods, I have made the payment to my supplier. If I had failed to file my Tran 1 by 27th December 2017, whether I was allowed to file Tran 1 on 28th December? Whether I was allowed to file? I was not allowed to file. It took an entire litigation up to Supreme Court wherein they allowed filing of Tran 1 from 1st October 2022 to 30th November 2022 when my value of money reduced to 50%. A credit which had been available on 1st of July because I was strong on merit was denied on procedural ground, and it was allowed after 5.5 years when my money value was reduced to 50%. So when the assessee is penalized for procedural errors, why not the officer should be penalized for the procedural errors? And we would be mistaking or leaving out on a very important ground if we would not be making it this as part of our submission. Whenever we receive a notice for 3B2A, our first submission is that I am totally genuine, I have received the goods, I have made the payment, I have done everything correct. Yes, this is part of section 155, burden to prove, wherein in case of e-com guild trading company, the Supreme Court has said that it is first upon the assessee to prove that he is entitled to credit, entitled to claim the credit. But at the same time, in my submission, I have to state that your notice is defective. It is not providing the relevant section in which I have committed the default. Your notice is not providing the relevant provision of penalty in which the penalty is to be levied. Either say I have committed all the 45 defaults, then I will reply to all the 45 penalties, or give me the specific provision in which I have committed the default. So this is a case of Delhi High Court wherein they have said that in case of show cause notice, the officer had invoked section 16(2)(c). Section 16(2)(c) is pertaining to non-payment of tax by the supplier. But while passing the order, they passed the order under section 16(2)(b). The court said that the allegation made in the show cause notice was pertaining to non-payment of tax by the supplier. How can you pass the order in case of show cause notice, the allegation of non-payment of tax by the supplier? How can you pass the order for non-receipt of the goods? The allegation should have been in the show cause notice. You should have invoked section 16(2)(b). If you have to pass the order under section 16(2)(b), it cannot be a case that you issue a notice under 16(2)(c) and pass the order under section 16(2)(b). So this is the power of making a proper submission. In this case, a decision by Honorable Delhi High Court again, wherein section 17(5)(b) was invoked, that your credit is ineligible under section 17(5)(b). What court said, mere invoking of the section is not sufficient. Why that section has been invoked? What is the default which has been committed by the person who has claimed the ITC? It is the equal responsibility, first responsibility of the officer to make the allegation. It is not simply that you invoke a section and ask the assessee to give the reply. So if the allegation is not there, only section has been invoked, that means the notice is incorrect. Now this is another case.
That means a void.
Yes, sir?
When we say the notice is void,
When we say notice is void, that we will discussing, sir. Now this is one case wherein it was said that once an order has been passed by the assessing officer and the matter is before the appellate authority, he becomes a functus officio. He cannot add something to before the appellate authority which is not part of the order. So when an appeal has been filed before the appellate authority, office is not allowed to add anything to the order which has already been passed. So many a times what happens that appellate authority seeks comments from the officer while the appeal is being decided. Now when the assessing officer sends his comments, he adds 2 further allegations. He adds 2 further evidences to the order already passed. Those evidences can never be added at the appellate stage by the officer. This is a landmark decision by the Honorable Supreme Court which has held for the last 60 years that once an appeal has been filed, whatever is contained in the order, it is final. No new thing can be added by the officer. So we were discussing why the written submission has to be very detailed. This is a GST regime judgment by Calcutta High Court delivered on 5th of May 2025. Latest decision delivered a month back. in the writ filed before the Calcutta High Court, the validity of the notification under section 168A, which extended the time limit for passing of the order under section 73, was challenged. See what Calcutta High Court observed. I am of the view that there is no scope to entertain the writ petition, especially having regard to the fact that petition at the first instance, after the aforesaid show cause notice was issued, did not proceed to challenge the same. That challenge to the validity of notification issued under section 168A was not made in the written submission, and once the order was passed without making a challenge in the written submission, a writ was filed. The Calcutta High Court said that this is not done. You should have made it part of a written submission. So that's why when we are filing the written submission, we are creating a foundation to the case. Sir, we are not here merely to make a submission which officer accepts. We are here to prepare a foundation for the case, and if we are preparing a weak foundation, that case when it will go upside to the High Court, therein that weak submission would come and haunt the assessee.
Generally, sir, the legal principle is that any legal ground can be raised.
That I have taken part, sir. But then when High Court makes this observation, you are left with no other option other than go to the Supreme Court. So better we are equipped with all the allegation at the SCN stage. Now coming to the instance of interpretation, that how an interpretation has to be made. Let's take a very interesting case study. This is section 11A of Central Excise Act. This is section 73 of the CGST Act. I am only emphasizing on the red highlighted part which has been underlined. Any willful misstatement or suppression of facts, any willful misstatement or suppression of facts. Does anybody see any difference between the two terms in section 11 and section 73? Yes, sir? Is there any difference between the red highlighted parts in section 11 of Central Excise Act and section 73 of CGST Act? Yes, sir? Presence of the hyphen. Who has said, sir? Yes, sir. Very correctly observed, sir. Now, what is the implication of change of the hyphen? See, this is the minute changes in the law which changes the entire interpretation of the term. Now, what difference has made by change of the hyphen from here to here? Anyone, sir?
One is to evade tax and evade.
No, sir. Change of the hyphen from mis-dash statement to willful dash misstatement. Anyone, sir?
Willful applies to only misstatement, not to the suppression of facts.
Very correct, sir. In this case, in section 11 of Central Excise Act, willful was attaching itself both to misstatement and suppression of facts. But in CGST Act, what they have done, they have placed hyphen between willful and misstatement. Now willful is only attaching itself to misstatement, it is not attaching itself to suppression of facts. Now the decision of Honorable Supreme Court in Cosmic Dicam in pre-GST regime, wherein they said that willful is attaching itself to misstatement suppression, has been nullified. Now this is the implication of change in a simple dash in the interpretation. So that is why when we are comparing two acts, whether it is a pre-GST Act and a post-GST Act, we have to be very specific that whether the provisions are perimeteria or any changes have been made. That we will be discussing during our deliberation. Now this is 11A and 73. Now coming to section 122 of CGST Act, because we very commonly receive notice, why not a penalty be levied under section 73, read with section 122. And they invoke section 122 because they say the 73 and 74 are not penal provisions. Any penalty which has to be levied in 122, we say, sir, 122 is independent, because 75:13 says any penalty, any offence for which penalty has been levied in the 73, 74, no penalty for same offence can be levied under any other provision. Now coming to section 122, make a comparison between 73 and 122. Again, the phrase highlighted in red, is there any difference? Now the hyphen is not there. This is the drafting error which we can take benefit while we are making our submission, sir. 73 and 74? No, sir. For high offensive which have been there in 77. Now coming to how mens rea can be incorporated in a civil statute. There are two types of offenses, criminal offense and a civil offense. Now in a criminal offense, mens rea is a ingredient which has to be proved, because without that a criminal offense can never be alleged against a person. But in civil offense, there is no requirement to prove mens rea. So supposedly, what is the difference between a criminal and civil offense? Supposedly, I have not generated an e-way bill. Now, if it is a criminal offense, it has to be proved that the e-way bill was not generated with an intent to evade. But if it is a civil offense, it would only be that whether e-way bill was generated or whether e-way bill was generated or not. That's it. Whether there was any intent to evade, whether there was no intent to evade, it is immaterial. So, there is a decision of Honorable Supreme Court under Rajasthan Sales Tax Act, Guljak Industries, wherein they said, similar to e-way bill, which is there in post GST, there was VAT 47 in that time. So in that case, Supreme Court said that only in special circumstances, if the declaration is not accompanying with the goods, then the penalty would not be levied, but in all other cases, penalty would be levied. So this is the difference between a civil offense and a criminal offense. Criminal offense requires mens rea, civil offense does not require mens rea. Now let's take another example. What is the difference between an incorrect invoice and a false invoice? Supposedly there is a provision which says that if you generate an incorrect invoice, there would be a penalty of 10,000, and there is a provision which says that you generate a false invoice, there would be a penalty of 10,000. Whether both provisions are same or both provisions are different. Yes, sir? So incorrect invoice is an invoice, whether it was generated willfully, whether it was generated non-willfully, it is offense. But when it is a false invoice, that means it was deliberately generated incorrectly. So this is the difference between the use of the words. So whenever we are reading through a provision, and there is the word incorrect invoice, it would having a different implication. It would be a false invoice, it would be having a different implication. Now, whenever there is a incorporation of mens rea, suppose it an incorrect invoice or false invoice, in both these instances, it has to be proved that there was an incorrect invoice. But when the term false is used, not incorrect, then there is an additional obligation on the officer to prove that not only it was an incorrect invoice, but at the same time it was generated deliberately. But if he is not able to prove that it was generated deliberately, even though the invoice was incorrect, no penalty would be leviable. So merely whenever we receive a notice and the department makes allegation that you have made a deliberate attempt to avoid tax, this is a bald allegation. It does not have a legs to stand upon it, because it is incumbent on the officer to make an allegation that it was done deliberately with evidence. It cannot be a mere statement. So whenever there is a difference between a criminal offense and civil offense, we have discussed now what is the criminal statute. It is an IPC, Indian Penal Code. It is a criminal offense. But by nature, whether GST is a criminal statute, leaving aside section 69, section 132, GST is a civil statute. Now, how in case of a civil statute, mens rea is incorporated? So this is a decision by Honorable Allahabad High Court which said, then when we have words like voluntarily, intentionally, negligently, knowingly, fraudulently, dishonestly, rashly, omits without lawful authority, that means mens rea has been incorporated in the civil statute. So not only proving that the offense was committed, it has to be proved that it was committed deliberately. So that is why there is a difference between a section 73 and 74. 73 is a normal non-payment of tax or irregular availment of ITC or erroneous refund, but 74 is a willful misstatement, fraudulent or suppression of facts to evade tax. So that's why whenever section 74 is invoked, there is an additional responsibility on the department to prove that it was done fraudulently, it was done willfully, there was an intent to evade tax. Now coming to a validity of press release. See, GST, normally what happens is, there is Constitution of India, in which a law is enacted. After that, rules are framed. After that, clarifications are issued in circular. After that, notifications are issued. This is the normal process. But in GST, we go reverse side. First, a tweet would come, then a press release would come, then a circular would come, then a notification will come, then a rule will come, and then the amendment in Act would be made. So this is how we go in GST, and normally this is completely upside down what other acts do. So now coming to the part of what is the validity of a press release. Now this is a Bombay High Court judgment given in November 2024. And we, everyone here would have remembered that when there was the onset of COVID, the sanitizer was being used regularly. So there was a query that what is the appropriate tax rate on GST on sanitizer, whether it's a medicament or whether it is something else. So if it is a medicine, it would be 5%. If it is something else, it would be 18%. So government came with a press release wherein they said that the tax rate on sanitizer is 18%. Now the matter was challenged and department relied upon the press release. So Honorable Bombay High Court said that press release has no validity in the eyes of the law. It is not a use of an executive power under Article 73 of the Constitution. See, it is very important that a press release is not issued under any power vested in the Constitution. So it has no legal backing. So that's why Honorable Bombay High Court said that you cannot decide a matter basis upon a press release. There has to be an understanding or interpretation of the law. So if the officer is solely relying upon the press release to decide a matter against a taxpayer, that order will not hold good, and that the matter was again remanded back to the officer.
What is the validity of council meeting?
But the validity, sir, validity of the council meeting is only for the understanding of the provision. It has no legal sanctity else. Validity of the circular going beyond the statute. This is a very common phenomenon. This is the decision by Honorable Guwahati High Court in September 2021, wherein they said that if the circular is going beyond the statute, it has no legal sanctity. And it has become very common that circulars are being challenged and circulars are being denied by the court that they have no legal sanctity. Recently a matter went before the before Honorable Supreme Court, wherein in 2022, if members remember, that there was a circular wherein the change in the formula for section Rule 89 was made for services being included for inverted duties refund, and some of the commodities were taken under the restricted category. So what the department said, that this is change which has been made and it would be applicable only for the application which have been filed after that date, and the benefit was sought to be taken from the assessee. Now the matter has been settled by the Supreme Court recently, wherein they have upheld the decision of the High Court and struck down the circular that it cannot take down a right which has been given by the statute or a rule. A circular is only a clarificatory thing. Now let's take there was a query during the discussion that whether a circular is binding upon the taxpayer. Now let's take an example. There are three pillars to the constitution. One is the legislature who makes the law. Second is the judiciary who interprets the law. And third is the executive who implements the law. Now when judiciary is interpreting the law, there are two equal stakeholders before the judiciary. One is the taxpayer, second is the department. They both are equal stakeholders. It is not that once the department is there, the taxpayer is at the downgrade, or taxpayer is offered and the department, they both are equal stakeholders. Now in this case, the department has been given the power under section 168 to issue a circular. And that's why whenever a circular is issued by the board, which is the highest body for the officer, it is binding upon all the officers. But can it be said that taxpayer, when the taxpayer is the equal stakeholder before the judiciary against the department? It cannot be said. Just because department has been given the power to issue a circular, that does not mean that they can regulate the assessee. Give the power to the assessee also to issue a circular, they will also issue their own circular. And then they will say, since I have issued a circular, it should be binding upon the tax department. Can it be so? If it is not possible, then the reverse also cannot be possible.
Should be within the framework of the law.
Should be filmed. Now, basic document for litigation. See, this is how a litigation starts and ends. First, either there is a summon, or there is an ASMT 10 or DRC 1A. Thereafter, an advisory letter is issued. So, we commonly receive from CGST department an advisory letter. All of you who are practicing in GST might have received somewhere, sometime, at some point at the time, wherein a letter is received that you are advised. Phone call. So if you are not responding to phone call, they send a letter. So they send a letter that you are hereby advised to reverse the ITC because your supplier is retrospectively cancelled. So there is a letter, then there is a show cause notice. In show cause notice, there is a relied upon document being supplied along with the show cause notice. Sometimes there are third party statements which are relied upon to make a matter against the taxpayer. After that, a reply is being filed, and upon that an order is passed, and against that order I file an appeal. This is the various stages of litigation, and we will be discussing each and every stage of litigation. So starting with the letter being issued, the letter which we normally receive from the GST department prior to the issuance of the show cause notice. This matter was before the Honorable Allahabad High Court, and it is a recent judgment given in September 2024. And what they observed about the letter being issued, what they said, the entire procedure is unknown in law. Counsel on behalf of respondent, that is the department, was not able to indicate any provision under which such a letter could be issued by the authorities. So that letter which has been issued by the department has no sanctity in the law. And what they do while issuing the show cause notice, they say that we have issued 3 letters, and against those 3 letters, none of the letters were replied by the taxpayer, no information was furnished by the taxpayer, and that's why they have an intent to evade, and we are invoking section 74 against them. So non-reply to the letter, they are invoking section 74 that you are not cooperating with the department. We only have to make a reference to this decision that when the letter does not have a legal backing, non-compliance does result in any conclusion being reached. So whenever a department is issuing a notice and levying penalty merely because the letter was not replied, you can rely upon this decision stating that issuance of letter has no legal sanctity. Now coming to concept of assessment in GST. Now this is one very important aspect which we have to keep in mind. This is a definition of assessment under GST Act section 2 clause 11. And it says assessment means determination of tax liability under this act. Now this is covering section 73 and 74, determination of tax liability under this act, and includes self-assessment. And includes self-assessment. That means self-assessment is equal to the assessment which is being made under section 73 and 74. That we all agree? Now what is self-assessment in GST? Section 59. Which says every registered person shall self-assess the taxes payable under this act and furnish a return for each tax period as specified under section 39. So whenever I am filing a return, I am declaring a tax liability, I am paying it off through ITC, and a return is uploaded in the portal. The first assessment in GST is completed. Please understand that the first assessment is GST is not notice of ASMT 10 issued under section 61. It is not a show cause notice issued under section 73 or 74. The first assessment in GST is the acknowledgement of GSTR 3B. And that's why when we go through the definition of assessment, it includes the self-assessment. So acknowledgement of 3B is having the same power which is of an order passed under section 73 and 74. So let's take another example, that whenever an order has been passed under section 73 or 74, can a mere statement that this order is incorrect hold the order invalid? The person who is making the allegation has to prove that why the order is invalid. So the onus is upon the person to prove that why the order is invalid. Mere statement that you have done a would not hold good for order passed under section 73 and 74. So this is the same legal sanctity of a 3B acknowledgement being filed. Whenever I am self-assessing my tax, it is the duty upon the officer to make the allegation along with the evidence that why my assessment was incorrect. He cannot say just that you have incorrectly applied tax at the rate of 5%, why not a tax rate under 18% shall be made applicable upon you. This is only a statement. He has to tell me that why the rate was incorrect, what should have been the correct rate, what was the reason that my rate was incorrect, why you are saying that the correct rate is 18%, what is the correct HSN, what is the correct place of supply, and what is the time of supply. All this is the responsibility of the officer to prove. It is not the responsibility of the taxpayer to prove that why he has applied 5%. It is the responsibility of the department to prove why 18% has to be applied. And this is the basic genesis of section 155. Why 155 is there? If 155 would not have been there, see, what is section 155? It says where any person claims that he is eligible for input tax credit under this act, the burden of proving such claim shall lie on such person. That means for ITC, the burden is upon me to prove that I am entitled for ITC. If section 155 would not have been there and only section 59 would have been there, the burden would have been on the department to prove why I am not eligible for ITC. Please make an understanding between section 59 and section 155. Section 155 places the initial burden on the taxpayer to prove why he is eligible for ITC. That means I have to prove why I am correct. So I am only required to prove why I am correct for ITC. For all other matters other than ITC, who is required to prove that I am incorrect? The department is to prove. So someday, can a mere statement say that I am incorrect? Whenever department is making an allegation against me other than ITC, they have to prove why I am incorrect. And in case of ITC, first I have to prove that why I am correct. So whenever we are receiving a show cause notice which is not covering ITC, if the show cause notice is not having sufficient proof that what should have been the correct tax rate, why it should have been so, what is the correct HSN, what is the time of supply, what is the place of supply, that notice is invalid. And this is a decision by Honorable Calcutta High Court in GST regime, wherein department sought to change the HSN and tax rate which was applied by the taxpayer. What Honorable Calcutta High Court said, the burden to prove rests with the taxing authority, herein the respondent authorities to substantiate their claims regarding the taxable nature of a particular case of item. Mere assertions in this regard holds no weight. So whenever I am receiving a notice, first try to distinguish whether it is for 59 or whether it is for 155. If it is for 155, that means ITC, the onus is upon me to prove that I am eligible for ITC. How that proof would be made? That has to be made as per the e-commerce trading decision by the Honorable Apex Court, wherein I have to furnish the proof regarding the supplier, regarding the document, regarding the payment, regarding the movement, and regarding the payment of the freight. Once I submit all those documents, the ball shifts again to the court of the department. But in cases other than ITC, the ball is first with the department. It is not upon me. I am not required to prove that why I have levied tax at the rate of 5%. It is the department which has to prove why the tax has to be levied at the 18%. Now there is section 7512, which has gained interest in GST regime when the amnesty scheme has been notified. 7512 is taking support from 59. What 7512 says, notwithstanding anything contained in 7374, that is, it overrides 7374, where any amount of self-assessed tax in accordance with the return furnished under section 39 remains unpaid, either wholly or partly, or any amount of interest payable on such tax remains unpaid, the same shall be recovered under the provision of section 79. That means 7512 says once a tax has been self-assessed, there is no requirement to pass an order under section 7374. You can make a direct recovery under section 79. They are not speaking about 83, which is provisional attachment. They are speaking about section 79, that there is no requirement to pass the order. If self-assessed tax remains payable, just go and attach the bank account and recover the amount. Why? Because 7512 treats that the assessment has been completed under section 59 by the taxpayer. And when the taxpayer himself has completed the assessment and he himself is saying that this is the amount which I am required to pay, where is the need to complete another assessment? Just go and recover the amount. He himself is saying that I am required to pay 1 lakh rupees as per one. And if he has only paid 20,000 in 3B, why there is a requirement to make another assessment at 7374? Since section 59 is for self-assessment, go and directly attach the bank account. 7512 is not covering issues for ITC. It is only covering issues for output tax. Because section 59 is for self-assessment of output tax, 155 is for ITC, which is not covered by section 59. So that's why section 7512 has been incorporated in GST regime for self-assessed liability, which has been declared in 1 but not paid in 3B. And that is why section 59, in my opinion, is one of the most important sections and powerful sections for the taxpayer. And if we are not using this while we are preparing a submission, and we are only replying to what has been alleged against us, that means we are losing out on a very important tool which has been vested for the benefit of the taxpayers.
Sir, is filing of GSTR what itself is a self-assessment?
Yes.
Yes,
GSTR 1. The explanation to section 7512. For the purpose of this subsection, the expression self-assessed tax shall include the tax payable in respect of details of outward supplies furnished under section 37, but not included in the returns under section 39. So 37 is basically GSTR 1. I am myself saying that this is the amount of tax payable. Now, then why do I need another assessment to tell me what is the amount which needs to be paid?
There is section 73, 74, 79, but why the department comes to 62?
Why department comes to 62? Huh? 16 subsection 2.
Because they declared liability in GSTR 1, but 3 was not filed. So, but the department...
I will take this. This is part of my next slides. So now what they have said that for self-assessed tax, section 7512 is the only mode for which the recovery has to be made. Now shifting topic from litigation and coming briefly to the amnesty scheme, because amnesty scheme is going on, and there is a circular which says that for a delayed reporting of liability or delayed filing of return, interest which has been levied for that amnesty scheme is not available. All of you might have read that circular that for delayed reporting of liability or delayed filing of return, if interest has been levied, amnesty scheme is not leviable. Amnesty scheme is not available. How many of you concur with the view of the circular? That if I have delayed filed the returns for 1718 to 1920, or I have delayed reporting my liability in the initial 3 years and interest has been levied, I am not eligible for the amnesty scheme. How many of you concur with this view? And how many of you do not concur with this view? Sir. So rest of the tax profession, what they are doing when they are facing this matter? Supposedly, I as a taxpayer, I am a client of yours, I come to you, sir, there is an interest in 1718 wherein I filed a return after 6 months. And there is an amnesty scheme, please apply for SPL 02 and make me eligible for the amnesty scheme. What would you be guiding me as a taxpayer? Whether you would be advising me to go for the amnesty scheme, or you would be saying, nahi, since order has been passed and the circular says that the interest is not covered, so you are not eligible for the amnesty scheme. So sir, none of you have faced this type of situation up till now in amnesty scheme? Huh? Let the case come. Let the case come, sir. So, leave aside who have not faced. Who have faced this matter, what they have advised. Sir, देखिए, what in my opinion.
Mostly match fixing solved our cases.
No, in the coming the cases which are coming as of now for 3 years.
Sir, SPL 1 and 2 is asking only the offenses under section 73 or 74. If it is under 73, whatever be the penalty, it is accepted.
Or about interest?
Yeah, interest not
If there is an interest and order has been passed under section 73, whether it is able to go under the amnesty scheme? Sir, in my opinion, that circular is going beyond the law. Because section 128A says that if the order has been passed under section 73 and if a tax has been paid, all the penalty, all the interest along with the proceedings would be deemed to be concluded. So why they have brought in that circular? They have said that for interest for delayed reporting of tax or delayed reporting of liability, section 7512 is there, and 7512 says that a recovery has to be made under section 79. So there is no requirement to pass an order under section 73, 74, and this amnesty is only for 73, 74. So how you are eligible for the amnesty scheme? What our submission is, sir, the mistake has been committed by the officer that he has passed an order under section 73. You had all the mechanism in the law to either pass a revision order under section 108, to file an appeal under section 107, but since you have not done, And the things which stand as on date is that the order has been passed under section 73. Therefore, merely because the order is passed under section 73, I am eligible for the scheme. And this circular is going beyond, because had the intention of the legislature would be to make me ineligible in these cases, they would have provided it in a similar manner for the cases which are covered by erroneously granted refund. Because erroneously granted refund is outside the scope of 128A, they could have mentioned this at that point also, but they have not done it. So your circular is going beyond the law. Now coming to evaluation of section 73-74. Coming to the evaluation of section 73-74, see, prior to section 73, there was section 67 which was there in model GST law. What it said, the phrase which has been highlighted in red, underlined, was not there in the model GST law. What it said, where any tax has not been paid or short paid. So what the GST Council in its agenda said, that the present provision which was in section 67, it is not providing for any process which would conclude that the tax has not been paid or short paid. So there has to be process included in the statute, that why it has been determined by the officer that tax has not been paid or short paid, or ITC have been wrongly availed or utilized, or refund has been erroneously granted. So therefore they included the word where it appears to the proper officer. Now this phrase where it appears to the proper officer is the process by which he would conclude that the tax has not been paid or short paid. Now this process can be anything. It can be a survey, it can be a third party information, it can be a DGgram report, it can be a scrutiny under section 61, it can be a survey under section 67, it can be a summon under section 70, it can be an access to business price under section 71, it can be an information sought under section 151. So therefore, when we go through the entire process, sir asked me that what is the relevance of GST Council meeting agenda. The agenda is only to understand how the law has evolved and what are the issues which were being faced and how those issues were removed. So it helps us in understanding that how the law has evolved, and precisely this is the reason. Precisely this is the reason in Devi Traders by Honorable Andhra Pradesh High Court, they have said that the word which have been used is appears, and it is not restricted to section 61. Had the intent of the lawmakers been that all the proceedings under section 73 has to be preceded by 61, they could have very well inserted where it appears to the officer by way of section 61 proceeding that tax has not been paid. So section 73 notice can be issued irrespective of the fact that section 61 proceedings have been commenced or not. Now coming to the do's and don'ts of the hearing, this is all about the basic understanding of the provision. What are the do's and the don'ts of the hearing? As you all know, opportunity of being heard has to be given, that is the given fact. Date, time and venue of hearing. Now there are multiple judgments of various high courts which have said that date, time and venue of hearing has to be given. And again I would emphasize, sir, while preparing a submission, don't think that whether this ground will hold good or not, whether the officer would be accepting this or not. Make a ground, because you never know which ground will work for you. We will discussing these issues in the course of this submission presentation. So if date, time and venue of hearing are not given, make it a point that this is a part of a submission. Time lesser than 30 days given for filing the reply. 73 says that 30 days have to be given for acceptance of the liability of payment of the tax. In no case lesser than 30 days can be given for filing of the reply. If any notice is giving lesser than 30 days, make it a point to challenge the validity of the proceeding that lesser than 30 days have been given to file the reply. Ex parte order not passed on the date of hearing. Now this is one interesting case, and there are two decisions coming from Honorable Allahabad High Court in this matter. Both are very recent decisions of 2024. What normally happens is a notice is issued for personal hearing. we are not able to attend the personal hearing, and 3 opportunities have been given, and none of on those 3 opportunities I was able to appear. Last opportunity was supposedly given in May 2025, supposedly take 12th of May 2025. I receive an order on 15th of June 2025, dated 13th of June 2025. So last date of hearing was on 12th of May. Order has been passed on 13th of June. There is a time gap of 1 month from the last date of hearing to the date of order. What Honorable Allahabad High Court has said, that order has not been passed, the ex parte order, on the date of hearing, and it has been passed subsequently, then the opportunity, another opportunity has been given to the taxpayer to appear and put forth this case. Either the order has to be passed on the date when the last hearing was there, and if the order is not passed on date and that subsequently, then another opportunity needs to be given to the taxpayer. This is the first decision, and subsequently this has been further upheld by Honorable Allahabad High Court, latest in 2025. This is latest decision of 30th of May 2025, just 15 days back, wherein going ahead, what they have said, then there is no concept of reservation of judgment by the officer. See, what we normally see in high courts is that on the date of hearing, the bench generally reserves the judgment and give it on a later date. So this is the same thing which was done by the Commissioner of Appeals in this case. He reserved the judgment on the last day and delivered it subsequently 1 month after. High Court asked the Commissioner of Appeals during the course of hearing, this is a writ proceeding, can you provide any specific provision which allows you the benefit to reserve the judgment and give it on a later date? They said that there is no such provision, and High Court quashed the decision which was passed subsequently to the date of the hearing and remanded the matter back to the Commissioner of Appeals for decision.
After physical hearing happened, the
Ex parte case, sir, not normal case.
after physical hearing happened, the authority can condonation delay was rejected by the appellate authority. Is it possible?
Sir, in case of appeal, even if the appeal is barred by limitation, say after 120 days, it is a mandate which has been given by high courts in various decisions. Opportunity of being heard has to be given, and the notice should specifically provide, or the course of hearing should specifically provide, that the question was asked to the taxpayer that why the appeal was filed belatedly, and replied to that allegation, and this is submission made, whether I accept it or not. So merely because they have given you a hearing, that does not mean that appeal has to be decided on merits. It can still be decided against you by if there is a delay in filing of the appeal.
My pocket. Can you put it in a coat pocket? It is losing some connection.
Acha, ठीक है.
Sir, nowadays officers are issuing so
Sir, एक मिनट, let me complete. We will discuss it. Let me complete. हाँ.
The same relevant
हाँ.
here. Officers are issuing a so-called notice by mentioning 3 dates in the same notice.
Yes, sir.
Either 1, 2, 3, whichever is convenient, you come. Is it correct?
Sir, recently Delhi High Court in its decision, although there are contrary decisions in pre-GST regime, but recently Delhi High Court in one of its decisions has said that practice of giving 3 dates in one go is something which has been followed, and they have somewhere down the line accepted that. I am not saying that this is the final thing, but in GST regime, they have accepted, although there is a contrary decision in pre-GST regime for that. Opportunity of being heard given prior to the date of filing of the reply. So supposedly I have got 30 days to file the reply. My notice is received on 15th of May. I have 30 days, 14th of June to file the reply. Opportunity of being heard is given on 10th of June. So Honorable High Court in multiple decisions, this is Delhi High Court decision, said that you cannot give an opportunity being heard prior to the date of filing of the reply. What would the assessee say if the date of reply is not expired? He has still 5 days to give his reply. He can only come and argue based on the reply. If his reply is not filed, what will he argue? So that's why all the proceeding wherein the date of hearing is given prior to the date of filing of the reply, it is a invalid proceedings. Now this is one interesting case, although it is very small, I would be discussing. And just to emphasize that which ground will work, you never know. This was a case wherein the last date to issue the notice for a particular proceeding was 31st of March. So the officer issued the notice on 31st of March. He gave a hearing on 18th of April. Now on 16th of April, he came to know that 18th of April is a holiday. Supposedly it is a Sunday. So what he did on 17th, he issued a revised notice wherein the date of hearing was 24th of April. Now the assessee challenged, sir, this change of date from 18th to 24th is a material change in the notice. And since this is a material change, so the notice should be treated to have been issued on 17th of April rather than 31st of March, because the integral change has been made to the notice. Honorable Bombay High Court in 1975 decision, which has not been challenged before the Supreme Court, held that the notice is time barred because date of hearing was an integral part, and since that has been changed, that notice should have been treated to be issued on a subsequent date, that is 17th of April, and since 17th of April is time barred, therefore the proceeding itself are time barred. Now this is one thing which we commonly see in case of DRC 01, because DRC 01 contains a column that what is the date of hearing. Though normally we in CGST we receive a NA in that case, and subsequently we receive a letter that your date of hearing has been fixed on this date. We can very well take the argument of this case that this is a material change which has not been communicated earlier, and therefore the proceedings are time barred if the date of hearing has been communicated for the first time after the limitation date. Now what happens sometimes that I have submitted all the documents. The officer passes the order that although the taxpayer had submitted all the documents, but he failed to submit these documents, and therefore his submission is rejected. Now this is a case by Honorable Gujarat High Court, which has been followed in many decisions in Delhi High Court also, that if the assessee has cooperated in the proceedings and submitted all the documents which as per him were correct and were only required, but if the officer had some other view that further documents were required to submit it, it is the duty of the officer to communicate that these are the documents which are further required to be submitted, and you have to submit these documents. It cannot be that whatever he has submitted is rejected and fresh documents are sought, and those documents are sought directly in the order. Whether 3 hearings are to be given mandatorily, this is a Delhi High Court decision, recent Delhi High Court decision in May 2025, which have said that if the assessee has appeared in one of the hearings and he has not cooperated and submitted, and his reason for seeking adjournment is not considered proper, the officer can very well reject the adjournment application and pass the order. It is not mandatory that 3 hearings have to be given in each and every proceedings. Even if the taxpayer did not appear on the date of hearing, but his written submission needs to be considered. See, this is the sanctity and the importance of written submission, that even if I am not able to appear physically on the date of hearing, but if my written submissions are on record, the officer say that since the assessee failed to appear, he has nothing to add and the order is passed as it is. He cannot say, because the written submissions are there on the record and they have to be considered while passing the order. Now coming to filing of the reply. This was all about hearing. Now coming to the filing of the reply. This is one Calcutta High Court judgment in GST regime, which is very important and emphasizes the importance of pre-GST regime judgments. What it says, that the authority failed to take note of the ratio decidendi which can be culled out in various decisions which have been relied upon by the appellant, more particularly the decision which were rendered during the service tax regime. So what they have said, that even if the assessee has submitted the decisions which were there in the service tax regime, and those provisions have been verbatim taken in the post-GST regime, those decisions will still hold good, and the officer cannot straight away reject those decisions that these are pre-GST regime, so I will not consider them. Let's take an example. For denying ITC stating that it is not a vested right, which decisions department is relying upon in GST regime? ALD Automotive? It is a pre-GST regime. VAT regime judgment? ALD Automotive? So when the department can rely upon themselves in the pre-GST regime judgment, what's stopping us on relying upon the pre-GST regime judgment while preparing a judgment submission in post-GST? अब देखिए, let's see. Can penalty be levied in matters involving interpretation of the statute? One common thing which we commonly see. Can penalty be levied wherein tax paid before the issuance of the SCN? Can penalty be levied when department had conducted audit earlier and knowledge about the activities of taxpayer? Can mere non-payment of duty is not equivalent to collusion or willful omission or suppression of facts? These are the common issues on which we see the judgments. Find the judgments in GST regime. All these issues have been decided by Supreme Court, by SESTAT, by High Courts in the pre-GST regime judgments. So we can rely upon those judgments. It is not that we have to only rely upon the post-GST regime judgment. Pre-GST regime judgments are equally applicable, but there is a condition attached to it. And this is the latest which I can download from the Taxman portal. There are 18,322 judgments for central excise. There are 7,936 judgments for central excise rules. There are 2,309 judgments for central excise tariff. There are 2,699 judgments for SENVAT credit rules, and there are 9,800 judgments in for service tax as on date on Taxman portal. This is only one tax file. So just say that these are pre-GST regime judgments and they will not hold good is not correct. Let's take an example that supposedly there was a provision on 1st of July 2017 in GST. That provision has changed as on date. So whether that judgment will hold good, it will not hold good. But if that provision has remained same from 1st July 17 to till date, whether that decision will hold good? Yes. So similar thing will hold good for the pre-GST regime judgments also. We have taken an example of section 11 and section 73, wherein the dash was changed, but wherein all of you might remember that there was a recent circular in December 2024, wherein they have discussed about the passive delivery and actual delivery. Wherein they said that if the delivery is complete at the door of the supplier and all the risks have been passed to me, still it would be considered that goods have been received. On which rule they have relied upon? On which rule they have relied upon? Rule 4 of the SENVAT credit rules. Wherein they have said that in rule 4 of the SENVAT credit rules, the condition was that the goods should have been received in the factory. But since the term in the factory is no longer there in GST law, and it only said that the goods should have been received. So therefore, now the paradigm has shifted from actual receipt in the factory to the passive receipt. So if the provision has remained the same, the decision will also hold good. If the provisions have changed, the decision will not hold good. That is whether it is pre-GST regime or a post-GST regime judgment. Now coming to the question, what is perimeteria? See, two decisions would be applicable whether they are pre or post if the two statutes are perimeteria. What is perimeteria? Honorable Delhi High Court in the judgment said, acts which deal with the same subject matter on same lines are perimeteria. Can we say that Central Excise Act and GST Act are perimeteria? Yes, definitely. Can we say VAT and GST Act are perimeteria? Definitely. Can we say service tax and GST are perimeteria? Definitely. So one thing is for sure that all these judgments, statutes are perimeteria subject to law not being changed. Now coming to the tool of interpretation, there are three situations on which we can decide whether the pre-GST regime or judgments are applicable or not. Use of same words in similar connections in both the statutes. That means judgments can be used. Authoritative interpretation of same word in same context in earlier statute. That means judgment can be used. Different language in later statute indicates change of interpretation was intended. So if the language has changed, prior judgment would not work, but if the language are same and the judgment is there, the interpretation would hold good. So now coming to the ratio decidendi. Now what is the binding precedent of a judgment? Commonly we come across various judgments. Ki, sir, SLP rejected of the department. Therefore the judgment of the High Court is now binding. What is the binding precedent? Whether the facts, whether the discussion on principle, or whether the conclusion. What is binding? See, there is a Supreme Court decision, Dalbir Singh versus State of Punjab, wherein they said that there are three parts of a decision. Finding of material facts, statement of principles of law applicable to the legal problem disclosed by the facts, and third is the judgment based upon combined effect of 1 and 2. So what is binding? Facts are binding, discussion is binding, or the final decision is binding. In the same decision what they said, however, for the purpose of doctrine of precedent, ingredient 2 is the vital element in the decision. This is the ratio decidendi. That means any decision which does not have a discussion on the statement of the principle of the law, it is not binding. So whenever we come across an SLP which has been rejected, and if it does not discuss it on the merit aspect, it is not a binding precedent. It still would be treated that the decision of High Court is final up till now, and Supreme Court has not given any view on that matter. See, this is Supreme Court decision 2022 Northern Operating System, wherein the secondment of employee was discussed. This is the same observation which they have made. What they have said, it is noticeable that the two orders relied upon by the taxpayer, that is SRF and Coca-Cola, these two are Supreme Court decisions. By this court merely affirmed the rulings of Sestat without any independent reasoning. Their precedential value is of limited nature. This was the case of revenue neutrality, wherein relying upon the two decisions of Supreme Court, SRF Limited and Coca-Cola, the assessee contended that payment of RCM is revenue neutral. And since Supreme Court has decided in two matters, so therefore this is a binding precedent before you, and in case of Northern Operating System, you have to follow that binding precedent. Supreme Court said that these two decisions only affirmed the ruling of the Sestat without independent reasoning, so therefore they have no binding precedent. There was recently a SLP rejected of the department in case of Suncraft Energy. Suncraft Energy was a decision given by Calcutta High Court, against which the SLP was filed by the department. Supreme Court rejected that SLP. Why they rejected? They specifically mentioned that we are rejecting this SLP looking to the amount involved in the matter. So now if I say that matter has been affirmed by the Supreme Court, this holds no precedential value because the SLP was rejected due to the amount involved. It was not rejected on merits. So therefore, whenever I am relying upon the SLP being rejected, it has to be specifically seen that why the SLP was admitted or rejected. Building upon a foundation of a case. Now this is one interesting case. As a case study I would be discussing. There is a very common notice which we receive. There is a very common notice which we receive, a letter received from the department that your supplier registration is cancelled retrospectively, so you are advised to pay the tax. Normally we do not reply to these letters. But these letters in such cases help us in building the foundation. How we can build upon a case? When we receive a letter of this nature, that since your registration of the supplier has been cancelled, therefore you are advised to pay the tax because the registration is cancelled retrospectively. Make a reply to that letter, providing all the document to discharge the onus of burden of proof. Provide the copy of the invoice, provide the proof of receipt of the goods, provide the movement copy, provide the payment of that freight. Now your burden is discharged under section 155. Now make a counter allegation that I have now discharged the burden of proof. Now let me know that what is the cancellation order of the supplier, whether that what is the reason of cancellation of his registration, whether the copy of the order has been provided to me, whether that cancellation order included that all the supplies which have been made to me were bogus or fake. Why this? Because see, when I will raise that copy of the cancellation order has to be provided to me. The question the department, why you are required to get the cancellation order? You are not the concerned person. There was an officer, there was an assessee, his registration was cancelled. He was delivered to him. Sir, section 107 of CGST Act, which provides for filing an appeal, it says any person aggrieved by the order of the adjudicating authority can file the appeal. Am I not the aggrieved person by cancellation of registration of my supplier? I am an aggrieved person. So I can also file a appeal against that order stating that why his registration has been cancelled from retrospective effect. Why the reasons were not provided to me being an aggrieved person. We have done this, sir. We have done this wherein we have asked for the cancellation order. That copy of the order was provided to us by the officer. We filed an appeal against that cancellation order before the relevant authority, appellate authority. Supposedly the registration was cancelled by Delhi officer. We filed an appeal before the Delhi officer and moved an application before our officer that until the appeal is decided, you should not move ahead for making the assessment proceedings. This is the first part. Now second, whether the supplier has filed his GSTR1, if he has filed, whether any action under section 79 was made against him, if that was not made against him, why not the duty being casted upon the office of the supplier to initiate recovery under section 79 when the self-assessed liability can be recovered directly by attaching his bank account under section 79? Why the recovery is being made to me? Secondly, if he has not filed his GSTR1, I am providing the copies issued by him, provided to the supplier registration officer, ask him to make a assessment under section 63 and ask him to make a recovery. Unless until he makes a recovery or passes an order against the supplier, you cannot proceed against me. Thirdly, if it was identified that the supplier was engaged in fake supplies, whether there was a specific observation in the order that all the supplies made to me were fake. See, there might be a case that there are 100 outward supplies made by the supplier, 20 of them are fake and 80 are genuine. And the order should clearly provide what 20 are fake and what 80 are genuine, or provide that all 100 are fake. So whether the order provides that what are the invoices or supplies which were made without any sale of goods. Alternatively, if there is a fourth reason that he has used ineligible ITC in paying the liability, the supplier has used ineligible ITC in paying the liability, I would ask that whether it is on record that ITC was used in discharging my liability. It might be a case that he had claimed ITC in April, he has made me supplies in October, that ITC in April was used in paying liability of April. It would not be a case of that ITC being used in October to pay off the liability. So these are the issues which we have to make a written representation to them. 100%, I give you 100%. That you will not be replied to this. There would be no reply forthcoming. And that is what we want. We don't want reply. Because if they will reply, again the ball will be in our court. Then we would have to make another submission to challenge that reply. So 100% cases, I have not received any reply till date. So you would not be receiving any reply. And once they have not made any reply and the matter travels up to say tribunal or high court, the high court says that the order has been passed without any information on record. And if we are not raising or we are not building the foundation of the case in this manner, and we are only submitting that we are a genuine recipient and I have received the supply, section 16(2)(c) will eat the client. Section 16(2)(c) will eat the client, and the High Court will say 16(2)(c) is constitutionally valid and therefore you are not allowed to claim the credit. So every document has a relevance, and it's upon us as a professional that how we build upon a case. For someone a letter might be a letter, but for someone the letter might be a blessing in disguise. And why this I have this? There is a Calcutta High Court decision in Diamond Beverages Private Limited wherein the same strategy was followed. And Honorable Calcutta High Court specifically said that whatever the objections were there after discharging burden of proof under section 155, order cannot be passed without discharging those obligations or question raised by the taxpayer. Now this is question of fact versus question of law, one which was asked. Now whenever I am preparing an appeal or a submission, there are two things. One is question of facts and second is question of law. Let's take an example. Order states that taxpayer is not possession of invoice. Whether it's a question of fact or question of law? Fact. Whether goods were received or not. Whether it's a question of fact or question of law? Fact. Whether constructive delivery, delivery contemplated under section 16(2)(b), question of fact or question of law? Question of law. So since there is shortage of time, so I would not be discussing in detail. Question of fact has to be raised in the first proceeding itself. If they are not raised in the first proceeding, supposedly order show cause notice stated that the taxpayer is not in possession of any invoice, and if I am not challenging it before the officer, I would not be able to raise it further in the appeal unless until the tribunal or the appellate authority grants me that opportunity. Rule 112 of CGST rules and Rule 31 of GSTAT procedure rules 2025, which have been notified, very clearly state that if any evidence was required to be submitted at the earlier stage and has not been submitted, the appellate authority or appellate tribunal would be well within their right to deny submission unless until a genuine reason is brought on record that why it could not be submitted earlier. See, initially we had discussed that after passing of the order officer becomes a functus officio. So same thing goes for the assessee also, that once a proceeding has been completed, an opportunity has been given to the taxpayer to furnish his evidence, he cannot be allowed to furnish new evidence at subsequent stages. Because if that prerogative is given to assessee, why that prerogative should not be given to the department? There has to be level playing field. So if officer cannot add, you also cannot add. And if you are allowed to add, there has to be special circumstances. So merely because department is allowing as on date, and they are not exercising power under Rule 112 to deny any fresh submission in appellate authority, it does not mean that it will not happen in future. So question of facts has to be finalized at the assessment stage. Question of law can be argued at any point of time. But it is better that question of law is also argued at the initial stages, because there is one decision which I discussed, because you have to the High Court that what view they take upon. So 5 minutes, sir. I have to conclude, that's fine. And this is section 58 of Indian Evidence Act. Facts which have not been challenged become an evidence. So if the notice states that there is no invoice and not challenging it, that becomes an evidence at the later stage. Prayer is something which we draft in a haste. But their decision, this is a decision of Honorable Bombay High Court, when they said that prayers are one of the most important part of the pleading. And if you have to ask a relief, it has to be part of the prayer, and if it is not part of the prayer, the High Court or the appellate authority or the tribunal would not be duty bound to give that relief to you. Now this is production of evidence, additional evidence rule 112, which I am talking about. Prerequisites of a valid order, unsigned order. There are a whole lot of decisions of Andhra Pradesh High Court, and Andhra Pradesh High Court is taking the lead in giving those decisions. Adjudication order to be a speaking order, because once an order has been passed, the officer becomes a functus officio. Grounds of submission and its consideration. This is one important aspect which I would like to discuss, taking 2 minutes. It's very important how we draft the grounds. See, these are 3 landmark decisions in GST regime. First, consideration to alternative issues only if main submission is rejected. We very commonly draft in the alternative and without prejudice to anything contained above and reserving the right to challenge on merits, we are making this ground. That means this is an alternative ground and our main ground is the prior ground. So whenever I am making an alternative ground, it is first thing which is required is that my main ground should be rejected. So how I sequence my grounds becomes a very important aspect. That's why whenever the jurisdiction of the officer has to be challenged, it has to be challenged as a preliminary ground. It cannot be at the last. If the validity of the notice has to be challenged, it has to be challenged as a preliminary ground. It cannot be challenged at the last. So how I see 3B2A, no section mentioned, this is a preliminary ground. I am a genuine supplier. 16(2)C is constitutionally valid. It is to be the last ground. It cannot be my first ground. Alternative arguments can never be considered as admission. See, somewhere down the line we say, in the alternative, even if I admit, I am ready to pay this amount. So that does not mean that I have admitted on merit for the entire. This is an alternative plea which can be treated as admission only to the extent I have admitted. It cannot be treated as admission for the entire case. Examination of each and every point of the reply. Whatever points are there, the officer is duty bound to examine either each or every point of the reply or the point which go to the fundamental of the matter. So that's why your reply, if your reply is detailed one, it's the duty of the order to consider, and if he is not considering, the first allegation should be before the appellate authority that my reply was not considered. Amount demanded in order cannot go beyond the show cause notice. Request for cross-examination. If a third party statement has been relied upon, there has to be cross-examination. Now this is a checklist for drafting of appeal, which as and when the presentation would be shared, can be gone through by you. With this, I would like to conclude my presentation, and thank you to the branch and the audience for giving me a patient hearing. And I have tried to do justice with the subject to the extent time I was allotted, and I also understand the constraint of the organizer because the president sir was there, so somebody has to bear the brunt. So thank you very much. Thank you all.
Thank you, sir. Thank you for your valuable insights.
Yes, sir. Which judgment, sir? Huh? RT Infotech, sir. Sir, see, various high courts are giving different judgments. Allahabad High Court, in one of their judgments, themselves said that if there is no payment of tax, credit would not be allowed. So we can take benefit of decisions which are favoring us and let the matter travel to the High Court.
Thank you, sir. Thank you for your valuable insights. Now, Suresh Jain Garu and SP Jain Garu to give it a memento to Arpit Haldia Garu. Now let's break for lunch. I request all the members to reassemble back to the hall by 2:15.